Hi, today I'm here in Cinque Terre, Italy. Behind me you can see the remote villages of the Cinque Terre, which literally translated means the five lands or the five villages that make up the Cinque Terre. And as you can see, there are steep and rugged cliffs behind them falling into the sea. For centuries, starting from the Italians to the Greeks, people have escaped to these villages to escape from persecution because they are so remote. You literally can't get to them and enjoy the natural beauty that exists here. And the reason that I'm here today is because this rugged beauty that was completely inaccessible is a very good metaphor for a discussion of background and foreground intellectual property. Now, to begin the metaphor, this beauty has been here for years. It's natural, it's always had it for centuries, but nobody could appreciate it because it was cut off from man. That is, of course, until the train came, giving everyone access to the Cinque Terre. Now, thousands of holidaymakers flock here every single day for a wonderful time in the sun. In our metaphor, the train is foreground intellectual property, and the natural beauty is background intellectual property. In commercial transactions, especially high-tech commercial transactions, there's usually a section of the party's contract devoted to what IP rights the buyer obtains in the deal. Most of the time, the rights are limited to use of the IP in the product as the product is intended to be used. However, standard contracts from buyers are increasingly trying to expand these rights. To begin with, the parties will come to the bargaining table with their own IP that has been independently developed. For example, the manufacturer will likely have IP that it's had for a long time in its base product. Sometimes the buyer will also have its own IP, often related to implementing the product specifications. This is known as background intellectual property or background IP. In our metaphor, Cinque Terre's natural beauty is the background IP. From this starting point, the parties will negotiate what rights they have to this background IP. Usually, neither party gives the other party any of its background IP. The manufacturer has limited use of the buyer's background IP to make the buyer's product, and the buyer has limited use of the manufacturer's background IP to the extent the use is connected with the product being used as it's intended. That's it. Sometimes, though, the buyer will want the right to the manufacturer's background IP to manufacture the product itself upon termination of the contract. This is a very rough end-run around an IP escrow agreement, and you need to be aware of something like this. Also, buyers may insert language into the contract giving it rights to create derivative works of the IP. Manufacturers should be vigilant to protect against giving these rights away. Generally, these IP rights are in addition to the intended use of the product, and if a buyer wants these rights to the IP that are in addition to its intended use, they must pay a premium for these. Once the parties start doing business together, IP can be created. For example, the manufacturer may improve the product over time. The buyer may contract with the manufacturer to create something new, specifically for the buyer. And/or a manufacturer may have a base product that it adapts or customizes to the buyer's specifications. This creation of new IP after the parties begin trading is what is referred to as foreground intellectual property, or foreground IP. Whether a buyer is entitled to use the foreground IP outside of the intended use of the products depends on what is being purchased. It boils down to this. Is the buyer paying for the unrestricted rights to the IP? That's where the train part of our metaphor comes in. What's more important to Cinque Terre? The background IP of its natural beauty, or the foreground IP of the train to get people here? That's not often an easy answer. Both are required, and that is why the contract has to clearly state these rights. Let's quickly look at the three scenarios just discussed. The manufacturer has to be really careful about its contracts related to foreground IP, because any manufacturer improvement to a base product during the term of the contract could fall under a broad definition of foreground IP. If the manufacturer has transferred the rights to foreground IP to its buyer, it may not be able to sell its improved base product to anyone except the buyer. Also, if more than one buyer has the same foreground IP rights, then the manufacturer could be in breach of contract whenever it improves its base product. Accordingly, manufacturers have to be very careful about the breadth of the definition of foreground IP and limit the transfer of it where appropriate. In the second scenario, where a custom product is designed and produced by the manufacturer for the buyer, the manufacturer will likely want to charge a premium for this work because it's likely selling unrestricted foreground IP rights. If the buyer does not want to pay the premium, the contract needs to clearly state that the manufacturer is free to sell products that incorporate the foreground IP to third parties. Finally, the most difficult issue is where the manufacturer's base product is specifically adapted to the buyer's needs. If a buyer shows the manufacturer how to adapt the manufacturer's base product to the buyer's specifications, the buyer will not want the manufacturer using that IP in a product it sells to anyone else, especially a competitor of the buyer. As such, the buyer in that situation should own the foreground IP. However, if the manufacturer is the party that figures out how to adapt its base product and does not charge the buyer for the adaptation, then the manufacturer should own the foreground IP. Conversely, if the manufacturer does charge the buyer for the adaptation, the buyer has a good argument that it has purchased the unrestricted rights to that foreground IP. In all three of these scenarios, the conflict is whether the buyer is buying the background IP, for which it has little grounds for an unlimited title, versus the foreground IP, for which it has better grounds for unlimited title. The manufacturer will likely think its base product, or background IP, is what brings value to the product and what creates value. Thus, to the manufacturer, no IP rights outside of the intended use of the product are transferred. Conversely, the buyer may believe that the real value is the IP used in adapting that base product to its specific needs. Thus, to the buyer, since the price is largely for this foreground IP, the buyer thinks it's bought an unlimited right to the foreground IP. For example, I represent a client that manufactures sturdy, high-tech equipment that can be used in the electrical components of trains, buses, city infrastructure, and electrical plants. Its customers come to it with difficult computing problems. My client is one of only a handful of companies that know how to implement these solutions in a product strong enough to handle some rough conditions. Now, in my client's mind, the real value in the product is the base product. Customization to fit the customer's needs is just the icing on the cake. However, in the customer's mind, it could be that it sees the real value as the customization of the base product and wants to own that foreground IP outright. Well, it's been a wonderful day today in Cinque Terre, and I think what we've learned is that, negotiations can hit a snag while the parties reassess their principal concepts of the deal. This must be addressed on a case-by-case basis. The business and legal teams must watch out for these issues in the fine print of the contract, and legal must confirm the business team's intentions to make sure that the contract accurately captures the intent of the parties. Make a mistake, and an expensive IP dispute could erupt. So keep your eye on these principles during negotiation, or the next time you see them could be in litigation.